Olá, pessoal. Aqui é o Joaquim Muniz, do CPA. Estou aqui com a Joana Egito, também do CPA. Nós somos organizadores do Rio Pre Moot, a 12ª edição, que é um circuito de pré-moots, né? A comunidade arbitral brasileira é uma comunidade muito unida e cada um toma sua iniciativa, mas acaba se coordenando para fazer algo o mais bacana possível, melhor experiência. E esse ano tivemos duas faculdades que se destacaram imensamente. Eu dividindo aí os quatro grandes pré-moots, começando no Rio, depois teve o do Souto Correia, agradecer o pessoal do Souto Correia, a da Kansas CBC e terminando no de Curitiba. Tivemos aí os títulos divididos entre o FRJ e a UFBA. E essa grande dúvida, as duas faculdades com desempenhos fantásticos. E então resolvemos, influenciados por esse espírito esportivo, né, trouxemos a Luísa Como, que é a grande organizadora do Premute de São Paulo, que é o da Kansas CBC, né? De São Paulo é apelido, o nome do Premute é o Premute da Kansas CBC, que também organiza um Pre-Moot europeu em Hamburgo, que ainda vai acontecer, mas esse é o encerramento aqui da etapa em terras brasileiras e a ponta de lança aí para caminhos mais longe, esse fazendo sucesso fora do Brasil. Obrigado, Luísa. Parabéns por organizar o maior premute do Brasil e organizar um premute na Europa, é um desafio imenso, né? Obrigado principalmente pelo seu tempo, né? Porque você não deve estar com pouca coisa fazendo um
Imagina,
premute lá.
obrigada, Joaquim. Parabéns vocês também por todas as iniciativas, tanto com o Pré-Moot do Rio quanto com o CPA.
E temos, então, houve muitos pedidos para colocar as duas faculdades para disputarem uma última vez, já fizeram semifinais e finais, as duas ganharam, e deixar registrado aí para todo mundo esse destaque de 2024. Então, temos a UFBA e o FRJ, agora para o deleite de todos que gostam de uma boa sustentação oral, que gostam de discussões de arbitragem e gostam de discussões de CSG. Então, agora temos, como é uma simulação de audiência, pessoal, vamos mudar para inglês, vamos fazer uma simulação como se fosse uma audiência, e temos aqui a Luísa como nossa presidente do painel.
So, good evening, everyone, and welcome to Vindabona. Uh, my co-counsels today will be Joaquim Muniz and Joana Egito, which I don't think I should present any further. It is my pleasure to preside this session. And so I would like to first start by asking if the teams have already had the opportunity to communicate between yourselves, and have you decided on either the order of presentation or time allocation?
Members of the tribunal, good evening. Opposing counsel, good evening as well. The parties have not yet agreed on the time allocation. However, respondents would like to suggest that we maintain the traditional time allocation of 14 minutes for the speech, 1 minute for rebuttal, and 1 minute for rebuttal, beginning with respondent on the procedural aspects, moving to claimant, and then claimant on the merits, and at the end, the respondent at the merits.
Is the claimant okay with that proposition?
Yes, Madam Presiding Arbitrator.
Okay, perfect. Well, I think it goes without saying that us arbitrators, we have few disclosures to make. That is that we've seen you on different sides already in this competition. But so I will just give you about 3 seconds for you to challenge any of the members of the arbitral tribunal if you wish to do so. But if not, then we shall proceed and we can go on and then start with respondent on procedure, which will be Cristiane or João Vitor?
João Vitor, Madam Presiding
Okay.
Arbitrator.
Perfect. Okay. So João Vitor, your 14 minutes starts now.
Thank you, Madam Presiding Arbitrator, members of the tribunal, opposing counsel, once again, good evening. My name is João Victor Sampaio, and I will plead on behalf of Visionic Ltd, which is respondent in our present dispute. Now, members of the tribunal, for the next 14 minutes, I will be addressing the procedural matters of our present case. Now, let me clarify the circumstances of this present dispute. After claimant has failed to comply with its obligations of disclosure about the cyber attack that happened in 2022, claimant now intends to present a new claim, entirely related to the issue of non-conformity and completely out of the scope of the present arbitration. Members of the tribunal, in regards to these issues, I will structure my argument in two parts. Firstly, I will address why this arbitral tribunal should not accept the addition of the new claim. And secondly, I will demonstrate to this arbitral tribunal that it does not have the power and should not, in alternative, determine the consolidation of these proceedings. Now, members of the tribunal, moving to the first part of my arguments, which relates to the addition of a new claim, it is firstly necessary to explain that even though the framework agreement partially regulates the purchase orders, it works merely as a gap filling, as the parties themselves have agreed that the specific provisions of the purchase orders should prevail over any general provisions of the framework agreement. Now, if I may kindly ask the tribunal to follow me to page 46 of the case files. And if this tribunal could please let me know when it reached the page. Thank you. Thank you. Now, members of the tribunal, this is claimant's own request for the addition of a new claim. Now, I would like to direct your attention to the third paragraph, beginning with following, and here I quote, following intensive negotiations between the parties, starting at the end of 2021, it was agreed that respondent could submit an additional order for the Central L1, which would be covered by the framework agreement in all aspects not specifically regulated differently by the parties. End of quote. Now, from this statement, we can have two conclusions, members of the tribunal. Firstly, that the purchase orders preserve certain autonomy. And secondly, that the specific provisions of the purchase orders would prevail over the general provisions of the framework agreement. And there are indeed specific provisions in our present case. The parties have chosen to implement different arbitration clauses in each one of the purchase orders, members of the tribunal, demonstrating the intention of the parties to surpass the general provision of the arbitration clause in the framework agreement. Therefore, the parties intended to have different claims arising from these purchase orders being discussed in different arbitrations, and such an intention should be assessed by this arbitral tribunal. But
excuse me, counsel. But if what is the same rationale applied to the arbitration agreement? So would the arbitration agreements apply only in that which is not specifically regulated? So the general would be applicable and not the specific? The general would be applicable unless it has already been specified in the preliminary, the other arbitration agreements, which were then signed by the parties.
If I may, like there's an umbrella agreement and a specific agreement. So they're not supposed to be contradictory. They're supposed to be complementary.
Exactly.
Well, thank you for the questions, members of the tribunal, Madam Presiding Arbitrator and Mr. Arbitrator. However, it is respondent's view that as the parties have chosen to implement a new arbitration clause without any mention to the dispute resolution clause of the framework agreement, it was their intention to revoke completely the arbitration clause inserted in the framework agreement. But also, this arbitral tribunal should take into consideration that the requirements set up on the ICC are also not fulfilled. Article 23, paragraph 4 of the ICC rules establishes that for the addition of a new claim after the terms of reference have been signed, this arbitral tribunal would have to assess the nature of the claims, the stage of the proceedings, and other relevant factors. It is respondent's submission that these requirements have not been fulfilled. Members of the tribunal, if we look into the nature of the present dispute, even though of the claims in dispute, even though we have claims related to the issue of non-payment, we would be discussing completely different issues under the first and the second claim. While in the first claim, we would be discussing the duty of disclosure upon claimant's side about the cyber attack that happened in 2022. The second claim relates entirely to the matter of non-conformity of goods, which is the reason for the non-payments. Therefore, the merits of these disputes would be completely different.
Yes, but aren't the parties the same, the agreements the same? The facts of the cases or the claims, the facts that give rise to those claims are they not the same?
Respondent respectfully disagrees, Madam Presiding Arbitrator, because even though there are some minor overlaps between the first and the second claim, we have completely different main questions at stake. For instance, at the first claim, had claimant any obligation of disclosure about the cyber attack that happened in 2022? That is an important question and the most important question before this arbitral tribunal. While in the second claim, were the goods sold from claimant to respondent in conformity with the contractual requirements? This is the main discussion at stake. Therefore, we have several different factors being discussed, not only on a legal basis, but also a factual basis. And according to Professor Christopher Imhoos, who worked, yes, I think
But ICC rules allow the parties to have different agreements subject to the same arbitration. So that's not per se a problem. It's more a problem of incompatibility, right?
Mr. Arbitrator, indeed, it is possible to have different contracts being discussed in the same arbitration and different issues, according to Article 9 of the ICC rules. However, Article 9 is also subject to these requirements of Article 23, paragraph 4. And at the moment that we see that the nature of the claims is so different because of the issues being discussed, then this is one of the requirements that this arbitral tribunal should assess in order to deny the addition of the new claim. And according to Fry, Greenberg, and Maza, for instance, in the Secretariat's Guide to ICC Arbitration, claims deriving from other contracts and a different set of facts are generally not authorized by the arbitral tribunals. Now, I understand that if we look to the second requirement, which is the stage of the proceedings, this arbitral tribunal would conclude that we are indeed still in an early stage of these proceedings. And I must mention that respondent is not contesting the compatibility of the clauses. However, whether the other relevant circumstances should indicate that this arbitral tribunal should or not accept this new claim. Now, even though the stage of the proceedings, members of the tribunal, is still early, what we have here is a situation in which claimant spent 1 year and 4 months to present a new claim related to the non-payment of purchase order A15604. We should also assess the fact that we have completely different issues at stake, and therefore there would be a clear disruption by accepting a new claim in this arbitration, even though in an early stage. Because this arbitral tribunal has two paths to choose. One, to complete the resolution of the first claim, and the second, to accept a new whole set of facts and legal provision into this arbitration, and therefore completely delay these proceedings. Which also takes me to the other relevant factors to be considered as members of the tribunal, which is the fact that we would not have noticeable savings in time and cost by accepting a new claim. It may even be necessary to nominate a specific arbitrator to assess the non-conformity of goods under the second claim. And we should also take into consideration that having these claims being discussed in the same arbitration would preclude the parties from nominating a specific arbitrators to assess the second claim. For instance, Mr. Victor Claimant.
Follow me, please. Under ICC rules, I can amend the claim until the terms of reference, right?
Yes.
So, claimant would be allowed, and under ICC rules, the claimant appoints the arbitrator with the request for arbitration, right? So before the terms of reference, right?
Yes, Mr. Arbitrator.
So your argument would be completely legal under ICC rules for claimant to add a new claim before the terms of reference, and this claim would be judged by an arbitrator that was appointed beforehand without the specific knowledge. So the outcome of which you are complaining, it might be unfair, but it does not go against ICC rules. You do not have the right to appoint an arbitrator according to that specific claim, because things may happen and claims may be added after the appointment of the arbitrator, right?
That is true, Mr. Arbitrator. However, as we are discussing Article 23.4 of the ICC rules, and there are other relevant circumstances to be considered, then we should therefore consider whether there would be a harm for respondent by adding this new claim at this moment of the proceedings. For instance, the nomination of the arbitral tribunal. And as claimant was aware about the defect of the goods before initiating these proceedings, while there was no claim in regards to this issue, there would be an advantage for claimants in regards to the nomination of an arbitral tribunal. And our client has nominated a specific arbitrator to assess the matters of cybersecurity at stake, but not the matters of non-conformity of goods, with all due respect to Mr. Victor Claimant. Now, members of the tribunal, this takes me to my first submission in order for this arbitral tribunal to deny the addition of a new claimant to these proceedings. Members of the tribunal, moving to the second part of my arguments, which relates to the consolidation of the proceedings, it is also respondent's submission that this arbitral tribunal cannot and should not accept the consolidation of these proceedings in the present case. Members of the tribunal, according to Article 10 of the ICC rules, the ICC court may determine the consolidation of the proceedings if certain requirements are met. Also, according to Professor Bernard Hanotio, no power is conferred to the arbitral tribunal in order to determine consolidation under the ICC rules. And even if we look at Article 1 of the ICC rules, members of the tribunal, it is clear that administrative powers are exclusively held by the ICC court, not by the arbitral tribunal. Therefore, this matter of consolidation should be discussed by the ICC court and not by this arbitral tribunal. However,
Excuse me, do you have any case law on that, which would clarify our interpretation of this article?
of course, thank you for the question, Madam Presiding Arbitrator. In the ICC case 2910, the arbitral tribunal, even though not deciding specifically on the matter of consolidation, took into consideration whether claimant's claim was presented under Article 10 of the ICC rules or not. When deciding on that matter, the arbitral tribunal clearly stated that the ICC court holds the power of consolidation in any scenario under the ICC rules. And this is the rationale that our client urges this tribunal to apply. However, even in the hypothetical event this arbitral tribunal recognizes its power to determine consolidation, then it is respondent's submission that the requirements have not been fulfilled. Firstly, because the parties have established the requirements of common questions and risk of conflicting decisions in their framework agreement. And there are no main common questions or risk of conflicting decisions in our present case. We are discussing duty of...
Excuse me, counsel, but ultimately, aren't isn't Article 10C all the requirements met after all?
Madam Arbitrator, if I may be granted 1 extra minute to answer your question. Thank you. Now, members of the tribunal, it is respondent's submission that not only the requirements of the framework agreement have not been fulfilled, but also the requirements of Article 10, including Article 10C. Indeed, the parties are the same in our present dispute, and we are indeed talking about compatible clauses. However, the differences between the clauses indicate the intention of the parties of having different arbitrations. And if we look into the third factor to be considered, which is whether the claims derive from the same legal relationship, it is respondent's submission that they do not in our present case. We are not only talking about different contracts, we are talking about different contracts that were negotiated by a different personnel, about different products that could be used for different purposes and that would be used for different projects. Therefore, we have a different legal relationship at stake, and therefore none of the requirements have been fulfilled. And it is respondent's submissions in our present case that this arbitral tribunal should deny the addition of a new claim and also deny any consolidation of these proceedings. Thank you very much. Now, of course, if I may be of any further assistance.
Thank you. Do the co-arbitrators have any further questions?
Because if you go following up of my colleague's question, then C, the claims are not if are the conditions if claims are not made under the same arbitration agreement. So there are some requirements, and we just analyze the requirements. So would you agree with me that if the rule itself set the requirements when the arbitration agreements are different, that means that the fact there are more than one arbitration agreement cannot be used as proof that the intention of the parties was to not consolidate, because the parties have two arbitration agreements but refer to SEC rules, and SEC rules allow. So
Exactly.
there's some
The
kind of
rationale,
contradiction in your argument.
the rationale behind Article 10 is exactly that when you have a multi-contract relationship, you can consolidate because it's time efficient and cost efficient.
Members of the tribunal, if I may only be granted the time to answer your questions. It is firstly necessary to explain that even though Respondent does not object to the possibility of consolidation involving different arbitration agreements, it is Respondent's submission that as the parties made the framework agreement in 2019, and then they made new purchase orders in 2022, 2023, with different provisions and specific provisions in regard to the dispute resolution clause. Therefore, it can be concluded that the intention of the parties was to have different arbitrations, as they had expressly agreed that the specific provisions of the purchase order would prevail over the general provision of the framework agreement. Now, even if the tribunal were to disconsider this argument, which is an unlikely event, and look into specifically Article 10C, still, even though the clauses are compatible, and even though the parties are the same, the legal relationship is different because we are indeed discussing different contracts with different products and which would be used in different projects. Members of the tribunal, therefore, a different legal relationship in the terms of the Secretariat's Guide to ICC Arbitration.
Thank you, João Vitor. If we could move on now to the claimant on the procedure aspects.
Members of this tribunal, esteemed opposing counsel, first of all, good evening. My name is Maria Clara Escrivano, and alongside with my co-counsel, Gabriel Figueiredo, we will both represent Censor X as claimants in the present dispute. And while I'll be speaking on the procedural aspects of this case, my co-counsel will address the merits of the dispute. Now, members of this tribunal, for the convenience of this arbitral tribunal, Claimant will mirror the same structure of arguments used by opposing counsel in order to demonstrate, first, that the new claim shall be admitted by this arbitral tribunal, and second, and subsidiarily, that consolidation can and shall be granted. Now, opposing counsel started its presentation arguing that the parties had no intention of having the same arbitration to deal with both claims, due to the fact that they signed different arbitration agreements. However, members of this tribunal, in accordance with Article 9 of the ICC rules, a single arbitration can arise from more than one contract and arbitral clause, and specifically to the argument that by making different arbitration agreements, this was an expression of intention, members of this tribunal. This is not the case here, due to the fact that on previous ICC cases, such as the ICC case 2236-4. On that case, although there was different arbitral clauses on different purchase orders related to a main contract, the arbitral tribunal understood that this was not enough to demonstrate the intention of the parties of having different arbitrations. And specifically, on the present case, the parties shows this intention of having a broad form of arbitration agreement. To demonstrate that, if the members of this tribunal could kindly follow me to page 11 of the case files, which is the framework agreement signed between the parties, Claimant Exhibit 1. And if the members of this tribunal are with me. So here on Article 41, which is the dispute resolution, on paragraph 2, on the third line from the bottom to the top, starting with it being the intention of the parties, It states, and I quote, "It's been the intention of the parties that this is a broad form arbitration agreement designed to encompass all possible disputes arising in connection with the present arbitration agreement and the contract concluded thereunder." So, members of this tribunal, here we have an express intention of the parties to have a broad form of arbitration agreements. And just for the sake of clarity, here, while it is Claimant's contention that the arbitral clauses of the purchase orders are indeed relevant, however, they must be seen as complementary to the framework agreements and interpreted all together, members of this tribunal. With this in mind, Claimant submits that this tribunal can indeed govern and judge the addition of the new claim. As per the other arguments brought out by opposing counsel about the fact that the requirements under Article 23.4 of the ICC rules are not fulfilled. As correctly brought out by opposing counsel, here it shall be assessed first, the nature of the claims, and second, the stage of the arbitration, and also any other circumstances this tribunal considers to be relevant. As per the first requirement, which is the nature of the claim, here it shall be assessed the degree of connection and similarity between the issues to be discussed and between the claims. Now, opposing counsel started its argument on the nature of the claim, stating that the discussions are different, and I quote, "Since the first claim, which will discuss the duty of disclosure of information of claimants, and the second claim will discuss nonconformity." However, members of the tribunal, here on both claims, the request of claimants is one of non-payment because claimants did not receive what it was entitled to under the different purchase orders. As per the second fact, members of the tribunal, indeed, both claims are governed by different individual contracts as stated by opposing counsel, which are the different purchase orders. However, these purchase orders have the general conditions governed all by the same framework agreements. And specifically, members of this tribunal, on the present case, there is an overlapping issue to be discussed on both claims, and this is the fact of the interpretation of Article 40 of the Framework Agreement. In accordance with Article 40 of the Framework Agreement, it shall be assessed this article provides for the requirements for an amendment on the Framework Agreement, and on both claims, this will be discussed. Since on the first one, it will be assessed if it was legitimate to respondent to understand that a change on the bank account could be done by email. And on the second claim, this will also be discussed, since the parties agreed by phone that a change on the notice of defect could be done by an email and not by the written form agreed on Annex 3 of the Framework Agreement. So here, the discussion is basically the same about contractual interpretation of Article 40. And therefore, it would be more efficient to admit the introduction of the new claim. As for the second requirement under Article 23.4, which is the stage of the arbitration. Here, opposing counsel mentioned, and I quote, that claimants took 1 year and 5 months to present this new claim, and therefore, this shall not be accepted. However, what opposing counsel did not mention is that claimants only realized about the non-payments 3 days before presenting this new claim. And this time to realize about the non-payment was done due to the cyber attack and the consequent IT shutdown, and the fact that the email sent by respondents never reached the claimant. In fact, members of the tribunal, in accordance with the ICC case 15-436, irrespective of whether the claim could have been presented before, if the arbitration is still on a stage that allows the counterparty to present its defenses, then it is better to admit the introduction of the new claim. And on the present case, the request for introduction of the new claim was done only 11 days after the signature of the terms of reference. In fact, in accordance with the procedural order number 1, this arbitration is still on its first stage, so there is plenty of time to respondent to present its defenses.
Thank you, counsel. May I just ask you, I think that it's very persuasive, the point you are making, but could you please address the fact that opposing counsel mentioned that there were only minor overlaps regarding the nature of the claims, and especially I would like to hear more from you about the complete disruption, which is what opposing counsel also suggested that would happen, even though he admitted that we're still at an early stage in both cases.
Of course, Madam Arbitrator, starts with the first argument and the first question made by Madam Presiding Arbitrator about the minor overlaps between the claims. Here, it is not a minor overlap, since the main issue to be discussed on the second claim is about the interpretation of Article 40 and the notice of defect, and if this notice of defect was done on the proper form. Because in accordance with Article 15 of the Framework Agreement, if this notice of defect is not done on the proper form, then the party is precluded from requesting defects. And therefore, if this analysis of Article 40 provides that the notice of defect was not done on the proper form, this would be the main issue to be discussed on the second claim. And it will not even be necessary to assess, for example, the defects and the proper nonconformity of the goods, because this would be a minor issue. So here, the fact of Article 40 is the main topic to be discussed on the second claim. And this shows that the overlapping issues are not minor, as opposing counsel suggested. As for the second...
counsel, but if you go beyond, of course, like you have a defense and you assume that your defense is right, but you have like a second battleground if you lose that. For instance, in the new claim, the quality of the goods. And would you agree with us that the quality of goods is something completely different from this hacker, phishing, those cyber attacks? Those issues are very different, and you can, and if you dismiss, I'm not prejudging, but if you dismiss your first line of defense, then you're gonna have two very fierce second lines of the defenses on very different technical subjects, and then the arbitration will take longer because you have to submit evidence on two completely different technical issues, probably with two sets of experts, things like that.
Indeed, Mr. Arbitrator, it is Claimant's submission that it will not be necessary to evaluate the quality of the goods. However, if we had to go to the second line of defense, then the arbitral tribunal could bifurcate the arbitral proceedings to, on a first stage, decide the first claim and also the contractual interpretation of Article 40 and decides if the notice of defect was done properly or not, and only if necessary, go to a second stage to evaluate the issue of the nonconformity of the goods per se. And even in this scenario, it would be better to admit the introduction of the new claim. And this goes me to the second part of the answer to the Madam Presiding Arbitrator about the complete disruption of the proceedings argued by opposing counsel. Here, there is no complete disruption of the proceedings for the fact that resolving everything together would be better, since the arbitral tribunal could interpret the same framework agreement only once. And even in the case of the bifurcation of the proceedings, this would be better as to the other option, that is, starting a new arbitration. As for the costs, Madam Arbitrator, also it would be cost-effective to admit the introduction of the new claim, since in accordance with the ICC cost calculator, a new arbitration will cost $480,000, and this amount, just for the sake of clarity, does not include neither the arbitrator's expenses nor the lawyer's fees. So the amount of savings would be even greater, members of this tribunal. And with that, Claimant submits that the new claim shall be admitted on this arbitral proceedings. However, on the event this arbitral tribunal decides not to admit the introduction of the new claim, it shall at least consider the possibility of consolidating the arbitral proceedings. Now, opposing counsel started its argument on the second issue, arguing that the arbitral tribunal does not have the power to decide about consolidation due to Article 10 of the ICC rules, that provides that the ICC court is the one with the competence to do so. However, members of this tribunal, the parties expressly agreed otherwise on Article 41.5 of the Framework Agreement, and on the present case, the parties' autonomy shall prevail. Opposing counsel mentioned the ICC case 19.
Excuse me. So, okay, let's say for argument's sake that all the requirements are met. Is it possible to derogate Article 10 of the ICC rules that states that explicitly states the power to consolidate falls on the court and not the tribunal?
Madam Arbitrator, yes, and I will answer your question on 2 points. First, it is not Claimant's contention to derogate Article 10 on its integrity, but only the part that grants the power to the ICC court to do so. The requirements of Article 10 can also be used by the arbitral tribunal while assessing the consolidation. And yes, the parties can deviate from Article 10 and specifically to the power of the ICC court to do so, since this was already done before on ICC cases, such as on the ICC case 21-873, in which the parties agreed to grant the arbitral tribunal with power to do so, and the arbitral tribunal did the consolidation, and this was not seen as a problem later on the scrutiny of the awards, for example. So this case shows that the ICC does not have a problem with arbitral tribunals deciding about consolidation. And on the present case, the requirements to consolidate are all fulfilled due to the fact that the parties the requirements under Article 10C of the ICC rules is fulfilled. Since there are the same parties, the arbitral clauses are compatible, as correctly recognized by opposing counsel, and there is the same economical relationship, since it is all about the same framework agreement and the same economic relation to the sale of the censors. And if I may have just an additional minute to answer my pleadings.
Please do. And I would like also for you to address the fact that counsel stated that because it's a different contract and a different product, then it's a different legal relationship.
Madam Arbitrator, it is not a different economic relationship due to the fact that the framework agreement encompasses all these specific contracts. And indeed, there are different censors. However, these censors are all governed by the same framework agreement, and it's on a bigger project of the parties. That is a project of the sale of the censors. And also, the requirements under Article 41.5 are all fulfilled, since there is a common relation between legal and facts, due to the fact that the parties have the same framework agreement and the same issues to be discussed about non-payment. And second, there is a risk of conflicting decisions, because if the arbitral tribunal one decides that a mere email is enough to change a provision of the framework agreement, and the other decides that it is necessary to have the written form as provided on Article 40, this would be a conflict decisions. And because of that, Claimant reiterates its submissions. Thank you.
Thank you so much. Any questions from the co-arbitrators?
Notice that, but the products, sorry, Counsel, for coming back to the same point. Like you answered well, my colleague saying like in your thesis that's the same relationship because there's a framework agreement. But the products are different and the non-conformity is different. And the technical issues that are going to be addressed are different. So how can we have efficiency if you are dealing with different transactions, raising different technical issues for us to address? Of course, assuming that your first line of defense are not accepted, that I'm not saying that, not deciding that right now. I just want to follow your line of thinking.
Mr. Arbitrator, in accordance with Article 1 of the Framework Agreement, this Framework Agreement establishes the contractual terms to the sale of the S4 censors, the ones of the first purchase order, and also the other censors. So this shows that the commercial relationship is of a big one that encompasses smaller relationships, but the bigger one is the same one, that is for the sale of the censors, irrespective of which specific type of it. And as for your question about the issues to be discussed being of technical differences, as previously stated, in a bifurcation of the proceedings, this would still be efficient, since starting a new arbitration takes for 3 to 6 months in accordance with Professor Berignou, and this time would be avoided by adding the new claim, or at least by consolidating the proceedings, that is the subsidiary request of claimant.
Thank you, counsel. So if we could go back to Mr. Sampaio with the rebuttal, you have 1 minute.
Thank you, Madam Presiding Arbitrator. Members of the tribunal, 2 points needs to be raised. Firstly, that opposing counsel has largely relied on Article 40 in order to sustain the existence of a common question between the claims. However, Article 40 is irrelevant under the first claim, because we are discussing whether respondents should be exempted under Article 80 of the CISG, not whether there has been an amendment under this claim. Secondly, members of the tribunal, opposing counsel has pointed to the hypothetical existence of the same common question, of the same legal relationship. However, according to the Secretariat's guide, this would refer to an economic transaction. And according to Ms. Berta Duran herself, claimant's head of sales in her witness testimony, the leader censure L1 would be used for a particular project of a limited size. Therefore, different economic transactions and different legal relationships. Thank you.
Thank you, counsel. And now back to Ms. Scrivano for his rebuttal.
Thank you, Madam Presiding Arbitrator. Members of this tribunal, opposing counsel just mentioned, and I quote, that the analysis of Article 40 would be irrelevant to the first claim. However, if this arbitral tribunal understands that there is no reason why a party can rely on an email to change a provision on the framework agreements, then the email was clearly a fraud and claimant and respondent could not have paid to it. So this analysis would be done on both cases. And as for the second issue, that is that both claims are about different common questions of fact and law, since the economic transactions are different. Members of this tribunal, this is not true, since the parties always treated them as something related to the same framework agreement and to the same general contracts. And this framework agreement serves as an umbrella contract that encompasses all the future relationships between the parties. Thank you.
Thank you so much. I think we should move on to the merits of the dispute. And for that, we give the floor to Mr. Figueiredo, if I'm not mistaken.
Thank you, Madam Presiding Arbitrator. As previously introduced, my name is Gabriel Figueiredo, and I'll be addressing the merits of the present dispute on behalf of CensorX PLC, the claimant in the present procedure. Members of the arbitral tribunal, time is money, and today marks 1 year and 8 months that respondent did not pay any of the $38 million worth of automotive sensors to claimant. And the longer the clock ticks, the more claimant drags the losses of respondent's non-compliance to its buyer's obligations. And in light of this, claimant has two main submissions. First, respondent is not entitled of exemption of payment under Article 80 of the CISG. And second, respondent cannot rely on any provisions of the CISG as well in order to request a price reduction. Now, members of the arbitral tribunal, before coming to its first submission, claimant would like to take a step back and provide the arbitral tribunal with a factual background of the present dispute. The present situation arose because respondent received a spoof mail sent from cyber criminals to their account manager, Mr. Royce. And here, members of the tribunal, claimant does not deny there was a claimant cyber attack in its internal system in January 2022. However, even though the email reached respondent with some red flags on it, respondent still interpreted the message as a legitimate email and also sent the amount to the cyber criminals before confirming such information. Now, members of the tribunal, the question posed to the tribunal is a simple one: if respondent is entitled to such exemption or not. And it's claimant's position that is not entitled to do that. And in order to prove to the arbitral tribunal that this exemption should not be granted, we shall analyze firstly Article 80 as was brought out by opposing counsel in the procedural aspects. And here, members of the tribunal, the analysis must be of the article itself, which you'll like to provide with it in its integrity. And I quote, "A party may not rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission." End of quote. Here, members of the tribunal, the key word is caused. And this is because the analysis that must be assessed here is whether there is a causality between, first, the act or omission of a first party, and second, the proof of the causal link between such act or omission and the lack of performance of the other party. However, members of the tribunal, such causal link cannot be assessed in the present dispute due to two main factors, and these are respondent's actions. Firstly, respondent interpreted the phishing attack as a legitimate message, despite the red flags contained in it. And secondly, sent the amount to the cybercriminals without prior confirmation with the other party, which is claimant. And here, members of the tribunal, such test is also provided by Professors Bianca and Bonnell and Schlenstern and Chiventa. And it was also utilized in the same rationale of the case, Stock Holdings case, judged in 2020 by the Stockholm Chamber of Commerce. And the test to be analyzed here, members of the tribunal, is if the respondent had enough means in order to understand that the spoof mail was legitimate as spoof mail, and also that it should have also confirmed such information in order to understand such a priceless matter to both parties, which is the contract itself. And in order to demonstrate that, members of the tribunal, I'd like to guide you all to page 16 of the case files. That is Claimant Exhibit C5, presenting the phishing attack sent from the cybercriminals to Mr. Royce. Is this tribunal with me? Thank you. So here, members of the tribunal, there are two aspects to be analyzed at first. So what we must look at here, members of the tribunal, is precisely the information which are the red flags contained in the email. And first of all, I would like to address this up to tribunal to the third paragraph from the bottom to the top, starting with the word unfortunately. And I would like to quote, "Unfortunately, I can only authorize delivery of the 600,000 S4 25889 sensors." End of quote. Here, members of the tribunal, what we have is the number of the sensor. In other words, the model of the sensor is spelled incorrectly. And this might seem like a small typo, members of the tribunal. However, the person which received such email was Mr. Royce, the account manager responsible for the relationship between both parties. And Mr. Royce here, members of the tribunal, such as Ms. Audie as well, knew all the details of the negotiations between the parties. And by looking at this model, which is not clear from the case files that even exist, this should also raise a red flag towards the interpretation of such email in the first place. And secondly, together with another wrong information, which is in the first paragraph, which is the purchase order, which is spelled incorrectly. And here, members of the tribunal, what we have is either one of two. One, it could be a different purchase order, which has nothing to do with the sanction regimes debate, which is in here. And second, it could be also a non-existence purchase order. So here, by looking at this, members of the tribunal, it should also contain that Mr. Royce had the means in order to interpret this email, and there was red flags pointing to that this could not have come from claimant. And on top of that, members of the tribunal, an objective criteria to look at this is the domain of the email itself. And this is because the address of the email on the very top part of it, it's spelled the censor X, which is the domain of the email, spelled incorrectly. Instead of an N, it's written with an M. And here also, it might look just a small detail, members of the tribunal. However, what we must assess here is that this is an objective character that changes the whole address that can be seen on the internet. It's much like a zip code, for example, in which if one small number spelled incorrectly, a parcel which was meant to go to Alaska ends up in California, for example. So one small character makes all the difference. And since here, what claimant contends is that even if Mr. Royce had any suspicions of this email, which is claimant's contention here, it should at least have confirmed. And that is precisely what Mr. Royce attended to do in the present dispute, members of the tribunal. However, in such occasion, Mr. Royce tried to contact Ms. Audie, which was the account manager responsible for the relationship between the parties, and reached her voicemail. And in this occasion, it was also said by Ms. Audie and stated by her voicemail that in urgent matters, a colleague should be contacted. And instead, Mr. Royce tried to also confirm the first information through the same means. In other words, he still sent the same message to the same suspicious email address, and therefore did not conduct a cross-check examination of such information. So,
excuse me, counsel. Sorry, I will I would kindly request you to move further in your argument, just because if we find that these 3 or 4 minor mistakes, they objectively were small details, and they could have easily been overseen by a reasonable person receiving many emails a day, which is what we do in real life on a day-to-day basis, you would probably not check the number of the purchase order while making payment. You would probably move past the number of the sensor. These are all just details that get lost on a day-to-day basis. So if you could move further on your argument, in order to persuade us with regards to the fact that Respondent had no suspicion, so had no reason to suspect the fact that this was a spoof email.
Madam Presiding Arbitrator, I understand your concern, especially in the part where indeed a lot of emails come and go in big companies like this one. However, here what we're talking about is a bank account modification for the transaction of $38 million. And here what must be assessed is that even though a lot of emails come and go, few emails do what this one attempted to do, which is the bank account modification, which has been done only once between the parties before. And here, members tribunal is relevant to assess that in the only one time in that a bank account modification was effectively diverted from Article 40 of the Framework Agreement, it was actually by a signed letter. And therefore, here, by doing it so by an email, which was not previously done by the parties in the specific case of a bank account modification, it shall at least raise a red flag towards Mr. Royce, since it was not a common practice between the parties. And therefore, it would also understand that before sending $38 million to an unknown bank account, which was not known by Respondent in the present case, is something to be suspected of. And it would not be one of the many emails we receive each day with other less relevant subjects rather than this one. So
I find that to be much more persuasive. Thank you.
Thank you, Madam Presiding Arbitrator.
If I may, counsel, getting back to your opening about causation, you are laying your claim on causation, but don't you think there's a risk that you go near something called concurrent causation? Because, okay, you're pointing out some mistakes from Respondent, but don't you think that the cause of the lack of payment is maybe a third party, or maybe, let's hear the other side, probably going to try to put the blame on you. I'm not prejudging, but don't you think there's a risk of concurrent causation? Because you're not pointing out something, maybe you're not pointing out something so serious to hold to Respondent wholly causing the mispayment. There are many other elements flying around. What would be the outcome of this case if we find there's concurrent causation?
Well, Mr. Arbitrator, your question leads me to the second part of my submission, which is the request of price reduction, and it also entails a duty to inform that also must be brought up by the Saptor Tribunal. But before going to the second submission, I would like to also address the co-causation here brought out by Mr. Arbitrator. And here, Mr. Arbitrator, it is a fact that there was an attack first in Claimant cyber system, and that is undisputed between the parties. However, within the same scenario, Mr. Arbitrator, it would also be reasonable for Respondent to understand that such a spoof email with a very important bank transaction would also regard a higher threshold in order to do so. And Claimant states that on the fact that under Article 80 of the CXG, that is a duty to cooperate established between the parties by taking a systematic approach interpretation of the convention. And here, in moving to the second part of the argument, members of the tribunal, that Respondent cannot request a price reduction based on Article 77 or Article 80 of the CSG, and precisely because of the duties that reside in them, which is precisely the duty to cooperate. And a duty to cooperate goes both ways, members of the tribunal. It is relevant also to understand that if both parties took action and reasonable actions in order to stop or try to detain an information to actually be provided for a negative consequence of the counterpart, it shall be done effectively. And what has been done in the present case, members tribunal, is that Claimant actually took action from the first moment in January 2022, once it found out about the minor cyber attack which transpired in their system. And therefore, they hired the best cybersecurity firm in Equatoriana in order to assess such attack. And secondly, when it was further found out about the seriousness of such attack, then Claimant shut down its IT system in order to protect the information, not only from respondents' information, but to all the clients that are with Claimant. And therefore here, afterwards, it still contacted the authorities in order to better assess the situation, and therefore having an existing intention of trying to mitigate eventual losses that might transpire. So here, Mr. Arbitrator, the answer to your question is that having a duty to cooperate from both ends should be analyzed from both perspectives, in the sense that Claimant, under the circumstances and also with all the tools presented to them, it also acted within the duty to cooperate under reasonability measure of the CISG. And therefore, the only thing that was standing by the phishing attack to be successful was the fact that Respondent was the one to interpret such spoof email, and therefore the one to have also interpreted the spoof mail as such in order to not send the amount to the cyber criminals instead of Claimant. And in light of that, Claimant would like to reiterate its submissions. Thank you.
Thank you so much. Do you have any questions, Ms. Ashita?
It said that like your client compliant, and that strikes me. Your argument that your client compliant because you could just let the market know about the attack. Then it will be beyond doubt that you have cooperated, but here you didn't. So don't think it'll get back to the same discussion of causation.
I understand your
And you're
concern.
just discussing what's the level of responsibility of each party.
Of course, Mr. Arbitrator, I understand your concern. However, in the present case, even though if there was a duty to inform in the present dispute, the information known by Claimant was that a server was encrypted, and therefore the communication system was off for a month. And therefore, the information that Claimant knew at the time was precisely this one. So therefore, the lack of information was not confirmed before, and therefore Claimant did not have the information to share in the first place. So therefore, if there was any of the information duties that Mr. Arbitrator stated that it could prevent the attack or prevent the respondent to see the phishing attack as a phishing attack, then it would also not be possible in the present case.
Let me understand the facts. You're saying that you didn't know like the telephone number of the respondent
No,
to give a call, or you didn't have the email, didn't have like a WhatsApp number, the address to send a letter, telex, don't know. No information whatsoever about the respondent, even in a contract of such a high amount.
Yeah, and I find it particularly interesting that all of the other clients were notified and not the respondent.
Well, I would like to answer the questions in the order that you were asked, assuming that I have the time to do so. So first of all, Mr. Arbitrator's question, the information here, Mr. Arbitrator, is that Claimant did not know about the data leak, and the data leak was also known a few months after the cyber attack actually happened. So here, the information to be shared did not contain within Claimant's information and Claimant's knowledge at the time. And as per Madam Presiding Arbitrator's question, there was an information to other clients, that is a fact. However, the information given to the other clients was precisely that the communication system was down because that the server was encrypted. So therefore, the information of the cyber attack itself was granted. However, the data leak itself was not understood up until a few months later.
Thank you, Counsel. If we could go now to respondent on the merits, please, Ms. França.
Thank you, Madam Presiding Arbitrator, members of the Tribunal, opposing counsel. Good evening. My name is Cristiane França, and I will address the issues of merits raised before this tribunal on behalf of Respondent. In this arbitration, Claimant tries to evade the financial repercussions of the cybersecurity invasion in its system caused by its own employee. Now, by relying on its own internal disruption, it seeks to leave Respondent bearing a financial prejudice that exceeds $38 million. In light of this, and opposed to what was raised by the opposing counsel, Respondent submits that Claimant is not entitled to receive any of the amount due under the Purchase Order 9601. In alternative, in the remote hypothesis that this tribunal finds that Respondent has somehow also contributed to the lack of performance, this tribunal should limit the amount that Claimant should receive to, at best, the minimum part of it. Now, moving to Respondent's main submission in today's hearing, Claimant is not entitled to receive any of the amount due under the Purchase Order 9601. And this is because Respondent is exempted from performing a second payment by virtue of Article 80 of the CISG. Members of the Tribunal, Article 80 establishes that a party is exempted from allegations of non-performance if such non-performance is a result of an act or omission attributable to the invoking party. And members of the Tribunal, this is exactly the situation in the case at hand. According to Professor Franco Ferrari, which is the professor of transnational litigation, arbitration, and commercial law at NYU, two elements are necessary for a party to rely on such provision. First, the existence of an act or omission attributable to the invoking party. And second, the existence of a causal link between such an act or omission and the lack of performance. Respondent will demonstrate before this arbitral tribunal that both elements are met. And this is because, firstly, Claimant committed an omission in terms of Article 80 when it did not disclose on the existence of the cyber attack invasion in its system, and this constitutes an omission in terms of Article 80 by means of a violation of a duty to inform. And second, that by not doing so, Claimant created additional risk to Respondent and therefore a causal link. Members of the Tribunal, according to Professor Ingeborg Schwenze, which is the same author cited by my opposing counsel, one of the main authorities when it comes to the application of the CISG for a member of its advisory council, an omission is constituted in terms of Article 80 when an action was necessary and suited to enable the performance of the contract. And this element is met in the present case. This is because what Claimant conveniently omitted is the fact that the cybersecurity invasion on Claimant's system was caused by Claimant's own employee, Ms. Audi, a high-ranking employee at the time of the incident. And in order to demonstrate so, I will kindly invite this arbitral tribunal to page 61 of the case file.
While we go there, counsel, I would like to ask you, what is the basis for the duty to inform that you are attributing to Claimant? But again, what is the page we're going to?
61, Madam Presiding Arbitrator. Well, members of the Tribunal and Madam Presiding Arbitrator, the basis on which Respondent is establishing that, in fact, in this arbitration, Claimant violated its duty to inform consists of the unilateral principles on international commercial contracts. And this is by virtue of Article 9, Paragraph 2nd of the CISG, which establishes that the parties are bound to international trade usage, even in the absence of an express agreement in this sense, provided that they are widely known and regularly observed. And this is exactly the case when it comes to the unilateral principles, because the decisions of several courts and tribunals do recognize them as having such a status. For instance, there is a decision from the Russian International Arbitration Court in which the contract that was being discussed on that opportunity was governed by the CISG, and the court resorted to the unilateral principles by means of Article 9, Paragraph 2nd, because they are recognized as international trade usage. Is this tribunal with me on page 61? Thank you very much. If I can direct this tribunal's attention to Paragraph 5, this is the procedural order number 2. It asks, and here I quote, "What were the exact circumstances of Ms. Audi's departure from Censor X?" And if I can direct the tribunal's attention to the third line from top to bottom, and here I quote, "For clicking on and download of the discount code for the car race was a clear violation, not only of claimant cybersecurity guidelines, but also of the prohibition to use the computer for private matters," end of quote. So members of the tribunal, here two things are clear. First, claimant was the cause of its own cybersecurity invasion. And second, even after claimant found out that it had the cybersecurity invasion, it did not notify respondent. There is a very much similar case from the Estonian Supreme Court in which the parties had concluded an international contract for the sale of chicken meat. In that case, after the due date of payment, the seller discovered that it didn't receive any payment from the buyer. It was later discovered that the buyer suffered a phishing attack requesting that the payment should be performed to a different account. In that case, it was not possible to apply Article 80 of the CISG because it was not possible to establish whether the source of the cyber invasion fell on the buyer or on the seller. As a contrast, in the present case, we do know for a fact that the source of the cybersecurity invasion lies on claimant. So this tribunal should apply the same rationale used by the tribunal in that dispute. Members of the tribunal, by not disclosing about the cyber attack, claimant did violate a duty to inform, which respondent will rely on the unijuris principles as previously mentioned. And this is because Article 513 establishes a duty to cooperate. That states, and here I quote, "Each party shall cooperate with the other party when such cooperation may be reasonably be expected for the performance of the party's obligations," end of quote. Likewise, Article 1.7 establishes that the parties have to act in accordance with the good faith principle in their conduct, and also in accordance with good faith international trade, and this provision cannot be derogated. Now, when it comes to the unijuris uncommentary to the principles, it establishes that those two articles, when combined, they do establish a duty to inform, and that this duty to inform is particularly relevant when it comes to long-term contractual relationships, such as a framework agreement. And this is because since the parties that are cooperating in the long term, every information is relevant to allow the performance of the contract. Now, as pointed out by Madam Arbitrator, it would be much easier in this case if claimant at least give any information to respondent. In fact, respondent was the only client of claimant that was not informed about the cyber incident because claimant issued an internal order for all of the account managers to give notice on their counterparts on the incident. Members of the tribunal, what respondent is stating before this arbitral tribunal today is not that a company is immune from being a victim of a cyber attack invasion, but what difference is the behavior of the company after receiving such an attack. In this case, when respondent was a victim of a cyber attack in 2020, it was quick and diligent in order to inform claimants on such an invasion. What the opposing counsel conveniently omitted is the fact that claimant specifically asked to be kept au jour about any further updates that respondent could have on the cyber invasion. And the opposing counsel stated that claimant was not aware that there was any data leak when it comes to respondent, but respondent gave notice to claimant on the cybersecurity invasion even before it was aware that there was any data leak. And according to the European Data Protection Act, which works as an advisory board for the GDPR, which is the best reference and authorities when it comes to digital legislation worldwide, if a company is aware that could be a risk of data leak, it should notify their clients. This was not respected in the present case. And by not disclosing, by failing to abide with its duty to inform, claimant created additional avoidable risk and therefore a causal link between its omission and respondent's lack of correct payment. According to Professor Thomas Newman, which has specific studies on the application of Article 80, even in the absence of an objectively established causal link, indirect causation would be sufficient to apply Article 80 if The party claiming the non-performance assumed a risk that falls within its own sphere of action. So here in the remote hypothesis that this tribunal finds that there isn't objectively established causal link, indirect causation would be sufficient for respondent to establish a causal link in this case. Members of the tribunal in this proceedings had claimant at least informed respondent that it didn't receive the first installment. Respondent certainly wouldn't perform the second one. So when claimant did not inform about the cybersecurity invasion, it assumed the risk of any further prejudice that this omission would result in the parties' relationship. Now, moving to the alternative arguments.
Okay,
Last
so in your understanding, I'd like to understand more if the notification of the data breach would have been enough to prevent, as the claimant says or alleges, that respondent's failure to perform.
Madam Arbitrator, is your question concerning the fact that could we guarantee that respondent wouldn't perform the incorrect payment if claimant gave notice about the cyber attack?
Especially in light of what says Article 79 of the CISG.
Madam Arbitrator, respondent does not contest that Article 79 is not applicable in the present case. It does concern situations of force majeure and hardship. What is respondent's contention here is that this tribunal should look at the bigger picture. So the only reason why respondents didn't try to pursue any further an oral confirmation was because of the fact that it had no reason to be suspicious. Because during the parties' relationship, they have always cooperated, and respondent expected at least a reciprocate behavior when it comes to giving notice of a cybersecurity invasion. Because when respondent suffered one, it informed claimant, and claimant was really interested in obtaining any further updates. So the parties' behavior during their legal relationship, and when it comes to this specific case in which claimant acted in a contradictory manner, is contradictory. So in fact, it is respondent's submission that had claimant let respondent know on the cyber incident, we wouldn't even be here today. Now,
Yeah, but counsel, I paid attention to what the opposing counsel said, of course, shifting the blame to you, but he made to a client, but he made some interesting points like gross misspelling of numbers and purchase orders, the fact that you could not reach the contact person and did not try to reach her or someone else, the fact that they are urgent to pay when payment was not due, that highly suspicious. So don't you think that a company under an attack would be in a little bit of chaotic situation, and your client would be somehow contributing to this chaos or to this incident by not trying to double check? Especially what strikes me the most is the need of urgency that is typical of scams, especially when you have a deadline. Your client ended up paying without doing this double check. So even I'll take a step back, like on hypothetical. Imagine that a claimant did some kind of internal control of payments, and in this internal control said, I have to go to some clients first because they have those payments first, and it will be on the end of the line. But then you rush it to pay because of this email. Don't you think that somehow your client was negligent, not thinking that, not considering that this rushing to pay was suspicious?
Mr. Arbitrator, firstly, there is there is not a material incompatibility when it comes to the information of the email, because it asked for urgently change the banking information, not to urgently make the payment. So an obvious phishing attack would consist if, for instance, the email requested that the payment was to be constituted before the delivery of the goods, which would be completely the opposite of what the parties had agreed on the procedural order on the PO 9601. What we need to consider here is that looking on the general scenario, as in the decision of the Estonian Supreme Court, in which in that case, the parties, the buyer received information that was highly confidential, only the parties had access to, and had no acknowledgement that a third party could have access to that information. The tribunal considered that that party was exempted from performing a second payment. This is the rationale that respondent respectfully submits that the tribunal should look into. Now, respondent did try to get an oral confirmation. It did try to call Ms. Aldi. It didn't pursue the matter any further, but this is justified because the voicemail exactly confirmed the last line of the email. Ms. Aldi was out of the office due to sickness complications. And since respondent had no reason to be suspicious, it trusts that claimant, if had any complications, would let respondent know. And this wasn't made in the present case. I see that my time is about to
So,
elapse.
Council, President probably going to give you enough time, just additional time, not to miss what you said.
Sure.
I could agree with you that they did not, with the fact that they did not rush for payment, but don't think that if the payment should be made in a long period of time, let's say, and they say, let's rush to change the info right now. Isn't that strange? Why would you need to change, to rush to change the payment info if no payment was due at that point in time? That's weird, right?
Mr. Arbitrator, respondent respectfully disagrees because, in fact, we need to look at the bigger picture. This is what the submission of respondent in the present case, because there could be typos which the parties have committed on different occasions, and the essential information was correct. So when usually companies, they do receive spoof emails, it consists of a complete different subject, of a complete legal transaction, of information that the parties look into, and they can state this is a phishing email, not sophisticated emails that was only received by respondents due to claimant's lack of diligence. Because what the opposing counsel conveniently admitted is that respondent was left on claimant's side for 126 days without an account manager. And the opposing counsel stated that time is money. But claimant took almost 4 months to discover that it didn't receive the payment. If claimant gave notice to respondent that it didn't receive the first installment, respondent certainly wouldn't perform the second one. May I be
Thank you,
of further
counsel.
assistance?
Yeah, actually, I think our time is up with you. Do you have any further questions, Ms. Egito, or can we move on to? Okay, so let's just move on to rebuttal, please, Mr. Figueredo.
Thank you, Madam Presiding Arbitrator. Members of this tribunal, the opposing counsel has used the Estonian case in order to have a legal basis for this after tribunal. However, in such case, members tribunal, there are two crucial important differences between the present case and the case law. And this is because the email in that case was sent by one of the email addresses from one of the employees at the company. And secondly, it was also utilized with no typos at all. So the invoices were all perfect together. So therefore here, it cannot also raise red flags, which is totally different from the present dispute. Thank you.
Thank you. Now, back to you for Sir. You have 1 minute.
Members of the tribunal, irrespective of what the opposing counsel raises on the Estonian case, at the end of the day, in that case, in which had no information that was different from the parties' relationship, the court concluded that since the claimant did not give notice on the invasion on its system, the respondent, in that case, the buyer, was exempted from performing a second payment by virtue of the principle of good faith. Thank you.
Thank you so much, Counsel. I believe that now the arbitral tribunal will reconvene. I'm not sure if we have a separate room, and I think we can just switch to Portuguese now. Moniz, you have the floor.
Nossa eterna presidente. Como é que a gente vai fazer aqui? Acho que a gente tem que. Vamos sair e vou fazer uma ligação aqui, deixar o floor para vocês.
A gente pode ir para um breakout room.
Pronto, vamos para o breakout room, então. Que
Então
não
tá.
é transmitido, né?
Isso.
Daqui a pouco estamos de volta.
Oi, Joaquim tá aqui?
Eu acho que, na verdade, a gente ficou na main room, não?
Oi, vocês estão todos na main room mesmo.
Eu acho.
Só.
Né? Vamos, de repente, a gente fica no mudo e eu faço uma ligação do.
Tá bom, pode ser.
Tá.
Não estamos te ouvindo, Joaquim.
Ouvindo?
Agora foi.
O pessoal está de volta aqui. Presidente, a palavra é sua. Você nos representa.
Tô esperando a Cristiane. Ah, voltou, Cristiane. A gente acabou não conversando se nós vamos dar feedbacks específicos, mas eu, infelizmente, tenho um compromisso daqui 15 minutos, então eu também não tenho muito tempo para feedbacks específicos. Vocês têm? Joana,
Não
Joaquim?
tem compromisso. Vamos
Então
Vamos
perfeito.
direto. Mas só parabenizando, até porque
Sim,
eu vi no começo, né? Eu fiz esse painel na SEMI no Rio, fiz a Bahia, né? Na SEMI da Cancer CBC, e cada vez mais vocês avançam. Teve um crescimento muito grande de vocês, isso é muito legal. E outra coisa é que vocês estão cascudos para pergunta difícil, né? Tá cada vez mais difícil colocar vocês, e é isso mesmo, tem que fazer o poker face. Vocês fizeram.
Sim, gente, do Premute do Rio, 30 dias atrás. Ah, só um segundo, que eu não tô gravando, só um minuto. Do Premute do Rio, de 30 dias atrás para hoje, vocês melhoraram assim da água para o vinho. Mas muito mesmo, as duas equipes.
não, isso de fato foi unânime entre nós já vimos vocês em situações anteriores e é admirável ver que todos vocês conseguiram evoluir nesses últimos dias, o que deixa a gente mais orgulhoso e mais esperançoso ainda para o desempenho das equipes brasileiras lá no Vismut. Então, parabéns. É, eu não vou me alongar muito nas nossas considerações, até porque acho que vocês já ouviram de nós considerações mais específicas em situações anteriores, e também a gente está super à disposição, caso vocês queiram conversar depois desse painel, mas a decisão também foi unânime, foi difícil, muito difícil para nós, então nós levamos em consideração uma míriade de fatores, então diversos fatores foram levados em consideração, e se nós pudéssemos avaliar esses fatores comparativamente, né, porque infelizmente ainda é uma competição e alguém tem que vencer, nós diríamos que na maior parte desses fatores vocês empatariam, então foi muito equilibrada a disputa, mérito e procedimento, nós achamos que, no geral, foi um excelente painel, mas por uma questão muito pequenininha, só para a questão de desempate mesmo, só porque nós não podemos sair daqui hoje sem dizer que uma das equipes venceu, nós gostaríamos de anunciar que hoje a Federal da Bahia ganhou o nosso painel. Então, parabéns para vocês. Mas, de qualquer maneira, muitos parabéns para a equipe do Rio de Janeiro. Vocês estão maravilhosamente bem. Eu espero que vocês tenham a oportunidade de treinar um pouco mais até Viena, todos vocês, e também de descansar um pouco para poder chegar em Viena já matando tudo a pau. E é isso. Muito boa sorte. Nós estamos muito orgulhosos de vocês.
Muito obrigado, pessoal. Tanto o pessoal da UFRJ quanto os árbitros também. Foi um enorme prazer. Sempre um painel muito apertado, muito difícil com os cariocas. Então, muito obrigado de novo.
Eu queria dizer que eu fico muito feliz de nós dois termos dividido, inclusive, a mesma quantidade de provas que a gente ganhou. Para mim, vocês são incríveis e, enfim, somos do mesmo nível.
Parabéns, pessoal. Vocês arrasam muito, como sempre. Parabéns.
É sempre um prazer
É
compartilhar.
sempre um prazer.
Já foram vários, né?
É,
A gente está contando aí os nossos
Em
painéis.
Hamburgo não, vocês não vão se enfrentar. Essa é a única garantia que eu posso dar para vocês.
No final.
Não vai ter essa
Não
emoção.
tem final. Hamburgo é muito próximo de Viena, então a gente não faz com final. Então, pelo menos isso. Mas
Mas
é
ó,
isso.
estamos esperando o prêmio dos quatro, hein? Que os quatro arrebentaram. Um orgulho para o Brasil. Boa sorte.
Parabéns. Muito boa sorte.
Obrigada.
Até
Obrigado,
mais.
pessoal. Tchau, tchau.
Tchau.
Parabéns a todos.
Obrigado.